Hey everybody, welcome to Active Self-Protection Extra. Recently had a case that I was involved in that went through trial. Thought I would give you just a little bit of insight on how that case went. It was a frustrating one on multiple levels. Let's talk about it. The Filster Enigma is a revolutionary holster chassis system that completely divorces your holster and gun from your clothing, giving you unprecedented concealment whether in sweatpants or formal wear. It attaches to your AIWB holster via the wing and allows incredible flexibility for your concealed carry. Get yours at the link below. So understand, I am just kind of letting you guys behind the curtain how these things go. Recently finished a case, and it was the first court-martial that I've ever been involved in. And in fact, as far as I know, I'm the first use of force expert. In fact, all the attorneys involved said so. The first use of force expert that anybody in the Marine Corps can remember. And I got to work with some fantastic attorneys on this case and some really good people. And it was a trial. And basically, the underlying charges were aggravated assault consummating in domestic violence. Okay. And so I want you to understand, as we get going on this stuff and as I tell you about how these things went, no expert witness gets hired on a case that's easy. Let's just remember that, all right? If it's an easy, cut and dried case, you know, you're a Boy Scout on your way to Bible study and you get attacked by a militant gang of narco criminals, you know, and you defend yourself from them and you know, those kind of cases I never see and I never get hired in. It's the ones where everything is a little sketchy, where they go, ooh, wait a minute, or there was some factors at play that the prosecution's like, nah, man, that was illegal, and the defense goes, I don't think it was, but I need somebody's really expert opinion on it. Those are the ones that I get involved in when there's significant disagreement between the prosecution and the defense as to what happened in that case. And often these have stink on them. Often they have underlying factors and truths on them that were no good. And as I'm sure you could think of, in a case involving domestic violence, there's going to be a whole bunch of stink here, and there's going to be a whole bunch of not very good. And in particular, I was hired in this particular case to talk about a video. There was a video of the pointing of a firearm by one party to the other party, okay? And that was a charge for aggravated assault, and that resulted in a charge of aggravated assault. And because that was aggravated assault upon a domestic partner, therefore domestic violence. And here's the thing. As it was shown to me and looking at things and then looking at the standard of the manual for court-martial, when you look at the rules for court-martial and under the defenses, 916, in particular in the defenses, this was a pointing of a firearm, which is in this case an aggravated offer of force. It's not actually an aggravated use of force under the rules of the rules for court-martial. It is instead an aggravated offer. And in the rules for court-martial, it says somebody can make an aggravated offer, can point a gun at somebody, in other words, if they reasonably believe that they are under the imminent threat of physical harm. So if it's an ordinary threat, the rules for court-martial allow for an aggravated offer, or what we would probably call a defensive display. So looking at the video, breaking it down frame by frame, talking to the defense team, I said, well, I mean, by the standard of the rules for court-martial, he's almost certainly justified to do what he did in that particular moment. Now, there's all kinds of stuff else around it that you could argue that there's, you know, that there was just a lot of unreasonableness. And as you could probably guess, in cases of domestic violence, there's he said and she said, and there's bad juju going both ways. And there's all kinds of discussion about who was the bad guy in this particular case and why did these things happen and who's at fault. But again, my particular argument was, hey, we want to talk about the video, and the video in that particular case, under the rules for court-martial, because again, is he reasonably under the threat of ordinary harm in that particular moment? I think a reasonable person would probably say yes, given the totality of the circumstances, and therefore I think it was justified conduct, even if I don't love some of the other stuff that had happened on beforehand by either party. So, asked them fairly early, hey, I would like to write a report on this and I'd like to get this written up. But the defense team said, no, I don't want to do that because I don't want to give the prosecution a bunch of information. I don't want to give them away our strategy. I want to leave them without that. And so I don't want you to write that. And I said, I think that's a mistake. I think that, you know, this is the way that we handle a Daubert challenge. So we had a Daubert hearing. The Daubert hearing I stood by for several hours. I didn't testify in the first Daubert hearing. The judge, I thought, had said that I could testify because they'd filed stuff back and forth. And I had done before this, I did a pretrial interview with the prosecutor, told them, here's what I'm looking at, here's what I see, here's why that is. I'm always very forthright with the other side. You want to do a pretrial interview? Sure, I'd love to, because my job is to educate you as well. And so let's look at that, and let's look at the evidence here, and let's look at what it shows, and this is why I think what I think. And so I'm not hiding anything from you. Ask me questions. I'm happy to answer your questions for you. So we did that. They did a Daubert hearing. I thought they'd handled that issue in the Daubert hearing, and the judge had said that I could testify. Turns out that he had actually kept it under advisement. And then the trial changed judges, and it changed dates, and it got pushed off a little while. That's all its own story. And then the way that they deal with things in the Marine Corps, a little interesting. They wanted me there for the entire trial. But again, I'll let you behind the scenes. The way that it worked, they had my fee schedule. I was like, all right, if you want me there for the whole trial, that's going to be expensive, but I'm okay. I prepared for that. Well, then Doge happened. And Doge comes and steals all the money out of their funding for experts. Well, we don't have any funding for you, John. We're working on finding alternate funding. All right, fine. Well, we got some of it back, John, and we need you to come and testify. We really need you in the case, but we can offer you basically a little less than a third of your usual billing rate. Man, I'm already all up in this case. I've already got all this stuff. Also, I really wanted to get admitted in a court-martial. I thought that would be a good thing for me and worth quite a bit, just for me personally to have. So I agreed to it. And then I went out for this trial. They had voir dire Monday, Tuesday. I got there Tuesday night. They had trial Wednesday, Thursday, Friday. It was scheduled Monday, Tuesday, Wednesday the following week, including me being gone from my family the weekend of Father's Day, which kind of sucked, to be honest with you, but it is what it is. So I just sat and took notes. They wanted me there for the whole thing, to listen to all the testimony, then to integrate that into my testimony. So, all right, if you want to do that, that's fine. They agreed to pay me again. It's not no money. It was pretty decent money, but it was about less than a third of what I should have been paid. Almost a quarter of what I should have been paid. So I took notes, I listened, I paid attention to everyone's testimony, the prosecution's entire case. The prosecution's first witness took 3 full days. That was the other side of this domestic, and they took 3 full days of testimony. So Wednesday, Thursday, Friday, all the prosecution's first witness. We didn't get around to talking about the defense until Wednesday afternoon the following week. And I was like, oh man, this trial's going long for sure. And it did. So then it was supposed to be a 4-day holiday starting on Thursday, because it was June 19th, Juneteenth, which is a federal holiday. But the judge had all of those folks come back, had the jury come back, had us all working on Thursday. That's fine by me. Then we did another Daubert hearing, and what came to light there was that the defense team made a couple of errors in how they disclosed me. So they did a lot about disclosing me in terms of my qualifications, but only just a couple of sentences on what I was expected to testify about. So they played really dodgy with, and tried to really minimize telling the prosecution what I was going to testify about. And the prosecution had asked for some more. They'd asked for another opportunity to interview me. I was like, that's up to the defense, not up to me. The defense team said no. And so I went up and testified for an hour and a half without the jury, and in another Daubert hearing, basically, and testified for about an hour and a half. Here's my qualifications. Here's what I'm expected to testify about. Here are some of the issues. Went back and forth. There was a direct and a cross-examination and a redirect and a recross, and I think I handled them very well. In the end, the judge, it was his very last trial before he retired. He was very kind to me. He said, this is no shade on Mr. Correa. He's clearly doing great work in his community. He's clearly qualified as an expert in use of force, but based on all of this stuff, I can't verify that his testimony will be reliable, which is the standard of Daubert. You can go watch our videos on that. And therefore, because I don't know what the principles are going to be applied to the facts of the case and how those are going to come to a conclusion, I can't verify those. Therefore, I can't allow the testimony because I don't have any basis for verification. So he disallowed my testimony. That does open up an avenue for appeal for the defendant, probably for ineffective counsel for the defense team not doing some of the things and some of the notices and some of the disclosures that they should have. So it's like an ineffective counsel appeal. And I'm not trying to cast any aspersions on those attorneys. They're good attorneys, okay? They had a lot of stuff going on in this case. It was a very complicated case. I mean, I was one of 6 experts. There were 4 experts for the defense, 2 for the prosecution that were there. And we were there for all of that. So I found that out on day 10. Yeah, so I left on Tuesday. It was the following Thursday, so day 9, that I found out that I wasn't going to get to testify. I was very frustrated about that. And I'm sure you can understand why, right? Like, this is the whole reason I'm here, is to testify. Now, I was able to help the defense team. I helped them with their closing arguments significantly and framing those things in the video that they got to show. I helped them significantly in some cross-examination of questions and preparing some for those things, and helped them at various times to make sure their stuff was put together and that they were ready to go on some things. So they were very kind to me. They said, "Man, we really felt like your consulting work was excellent." I had several attorneys. That was the only court martial that was going on at the time. So a bunch of the attorneys from the defense team, from the defense office, were there at various times. Had a couple of them. "Hey, I might have a case that I need a consult on." "Yeah, sure. Send me an email, shoot me a call. I'm happy to give you a consult. Talk about things." Got to meet the prosecutors, shake their hands. "Hi guys, nice to meet you." It's kind of, people expect it to be like, fisticuffs, but it's really not. It's more like the old cartoons of, Sam the Sheepdog and Wile E. Coyote, who will clock in and go to war for the day and then clock out and go have a beer. That's kind of more how it is. And so, it was a frustrating case. I flew home on Friday pretty frustrated about things. And in the end of things, the defense team did a great job of showing that there was a lot more complication here than the prosecution wanted to say. Out of all of the charges that the defendant was charged with, they acquitted him of all of them, except for the one charge directly related to the video, that aggravated assault charge. And they convicted him on that charge and sentenced him to 12 months of confinement and dismissal as an officer, which is the officer equivalent of a dishonorable discharge, which would it have changed things if I had been allowed to testify? Man, it certainly wouldn't have hurt. It might have changed things. It very well could have. Because again, when you break it down frame by frame and you're able to see kind of what was happening when and where, I think if we could have done some education there, that maybe it would have changed the outcomes. I wasn't able to do that, so I can't tell you what was going on with that. And that's the way that this stuff goes, right? The way that these things go, sometimes, the judge's job is to make sure the jury gets the most non-prejudicial version of the facts, and then the lawyers argue about what those facts mean, and the jury decides whether or not it was okay. Do I wish the judge had decided different? Yeah. Do I think he made a mistake? Yeah. Do I understand why he chose the way he did? Yeah. Would I have chosen differently? Man, I'm not a judge. I don't want to stand in that role. That's a lawyer who's playing lawyer for other lawyers, and that's a tough job too. And I don't think the judge was a moron or an imbecile. I think that I disagree with how he made the decision. I think that the defense lawyers were fantastic and did the best they could given what they had available to them. I think that they made a couple of tactical errors in how they disclosed me, and not allowing me to write the expert report, or not being able to fund the expert report, was really the problem because of Doge. And so that was an issue. And I think that given all that, I wish the jury had gotten a little bit better education on the whole issue, but they didn't. So in that particular case, the defendant was convicted, and is he going to appeal? I don't know. That's a great question. I didn't get a chance to ask that question before I came home. It was my first time watching a court martial. It was very interesting. An entirety of a court martial, very similar, just a lot more formal. Similar, but very similar, but a little bit more formality than in some cases that I've seen in civilian courts. But a lot similar. 8 jurors in this particular case, 8 members of the panel. They don't call them jurors in a court martial. They are a court martial panel. 8 members in that particular panel. And so, I think that the jurors were obviously good people. They're all Marine Corps officers, and let's see, a bunch of majors and a couple of captains. And so I think it was an interesting experience. I learned a lot. I will tell you my takeaways from it. I'm never doing another case that I don't get to write a report. If we're going to trial and you don't want me to write an expert report, I'm not your guy, I'm out. I'm not gonna, I think it's a waste of time. It frustrated me to no end. So I'm gonna be an advocate for myself in that and say, hey, I'd love to help you. This is how I can help you. If you don't want me to do that, I ain't your guy. And I'm just gonna stand on that. And number two, man, part of this challenge is that the Marine Corps said, hey, we'll pay you this amount for 5 days of trial. Then when they changed, and I said, okay, fine, I'll do that. And then when it came to it, it ended up being 10 days total with travel because of the weekend and because they changed the date of the trial and changed judges. And I said, okay, but we got to talk about money here. And they said, no, you already agreed to your fee for this trial. You agreed to a fee for the totality of the trial. And therefore that's what you get. I ain't doing that again. That's, it frustrated my family to no end. It frustrated me because I had to spend 10 days away from home, which meant I know all of you here at ASP realize that you didn't miss a lesson on any given day, which is good and important. And I still have to run active self-protection and bring you the education that I do every day. And I had to kill myself to get that far ahead in order to leave for 10 days and still maintain all of the content on the channels. And to do all that for that kind of little bit of funds just ain't worth it to me. So we ain't doing that for a quarter of the fees again. Anyhow, that's how the latest one went. I have another one that might go to trial at the end of this month. We'll see how that one goes. And right now, that is the only trial I have on my calendar. I have another case that I'm working that is just kind of getting going that I hope won't go to trial. I'm writing a report on that one in the hope that it probably will just get, that the prosecutor will drop charges. So we'll see on that one. Anyway, that's how this last trial went. I hope that helps you kind of get behind the scenes and understand what that does. And I hope you have a great day.